And the next speaker, whom I also want to ask to come here on the stage in physical terms, is Egidijus Verenius from State Data Protection Inspectorate in Lithuania. He is a head of legal department, and his topic will center around unsolicited communications and ethical considerations. Thank you, Egidijus, being with us, and the year and floor is yours.
Thank you. So good afternoon, everybody. I'm very grateful to be in this conference as a representative of Lithuanian Data Protection Authority. And today my mission is to talk about unsolicited communications, and more precisely about ethical considerations regarding them. So let me begin with a short history of how data protection against unsolicited communications started in European Union. It started with a directive which was approved in 1997, Directive 66. It talked only about unsolicited calls, and further protection was expanded quite shortly after, in 2002, by Directive 58, which is also known as e-privacy directive, which is in force now, and it expanded protection against unsolicited communications to not only unsolicited calls, but any other communication systems, also emails. And it does not stop here. We see initiatives in the European Union, and the newest one, although not enacted yet, is regulation on privacy and electronic communications, widely known as e-privacy regulation, which further expands on the protections regarding calling line identification and prefixes. However, it is a proposal now, so how it will go, we will see. Because we can't tell yet what will be the end result. I think the important thing here is the reasons for that legislation. And first and foremost reason is intrusion into privacy. So all the acts that I talked about are enacted from this point of view. Or when we look into e-privacy directive, it also talks not only about intrusion into privacy, but it also talks from this perspective that unsolicited communications may pose a burden or some kind of cost on the recipient. So we see that we are not talking only about privacy, but from the point of view of the customer that gets that unsolicited communication. And when we look at further initiatives in the European Union, and more precisely about e-privacy regulation proposal, we see that wording is getting stronger. Unsolicited communications are called as a nuisance directly. So we see that it's getting more user-centric. From the legislation is looking from the perspective of the user. So I think these reasons are very important because it shows that there are ethical considerations to be taken in consideration. However, it's not only legislation that is important. Also, a big role in how unsolicited communication should be should be viewed. That important role is from European Union Court of Justice, and the last case I think is very, very enlightening, and is clear by saying what should be considered unsolicited communications. So I'm talking about last year's decision, which was taken in November 25th. So basically, the case was about advertising messages that are displayed in the inbox of the customer, and they are marked like with the mark advertisement, but as I said, it's a part of the inbox. So when the court deliberated in this case, and what he clearly stated in this decision, that the list of means of communication is not exhaustive. So we are not talking about like traditional ways of sending direct marketing communications, like emails, like short messages or phone calls. We see that the understanding of what is a communication is broad. Also, what the court considered is that the appearance of these messages within the list of the user's private emails impedes the access to those emails in a manner similar to that used for unsolicited emails. So what that means is that those messages, even if they were marked as advertisements, were considered as unsolicited communications. But that's not only the thing that court considered. We see that the court went past, in a manner, went past the considerations of e-privacy directive, but also talked about interest and trust of the subscriber, of the person who gets those emails. So I think it shows that the court considered it from the point of view of the customer, and it shows that ethics are important here, because part of the ethical organization or ethical communication with the customer is customer's trust here. So all in all, those messages that appeared in the inbox of the subscriber marked as advertisements were classified as communications, and they were deemed as unsolicited marketing. And of course, one last thing that court considered is the test of nuisance of those unsolicited communications. And we see that e-privacy directive does not require to do such a test. Then it means that if an organization sends an unsolicited communication without consent, no such test should be done. But not only legislation is important here. I think what we see from our statistics as Data Protection Authority, customers really do care about how they are communicated with, and quite a lot of complaints we have from data subjects or subscribers, to be precise. We see that in 2019 we had almost 20% of the complaints regarding direct marketing. Now it's a little bit lower. These past 3 years, it's around 12%, but it's a considerable amount of all our complaints. So what we can see from this statistics that the customers care, they look for ways to protect themselves, and we see that organizations should think about how they communicate, if they communicate with customers in the way that could be trustworthy, in the way that is in line with e-privacy regulation, e-privacy directive. Sorry. So what we can see from all this legislation and courts decisions, and what we see from our statistics as Data Protection Authority, that ethics also plays a role here, and that role, it shows how organizations should think about communications, and how organizations should talk to their customers, and that is closely related with building mutual relationship, which is built on trust and fairness between the customer and your organization. Also, trust and mutual relationship is very closely related with organization's reputation. We see that if we live in a digital era, so customers can show how quickly show how organization is communicating, if it's communicating well, if it respects the customer, and if customer thinks that it's not happening in a way that he thinks it should be, or in a trustworthy manner, they can easily share those opinions in social media or any other outlet. So reputational loss is a very, very significant thing that should be considered when organization sends communications or direct marketing messages. And of course, last but not least, trustworthy way of communicating with customers helps to comply with legal norms. So, organizations should think about how to promote that trust, because trust directly is direct part of ethical organization. Yes, so this is very important, and I want to share this opinion, how it is important. Thank you.
Thank you, Egidijus. I am taking the keys of the conference, so I have 1 minute, so I will be extremely brief with one question. You showed the graph, the statistics of the claims related to unsolicited communication, which is decreasing a bit. What is your prognosis and forecasts for the next 1 or 2 years? Whether it will increase gradually or whether it will be more or less stable on the same level?
I think probably next year it will be stable, because we see the trend, like it's not going up, but it depends on I think e-privacy regulation, because what we saw from GDPR's entrance into force, people got more active. So e-privacy regulation, I think, will have the same effect.
The boosting effect, right?
Yes,
on these type of claims, right?
Yes, because the sanctions are getting bigger, if they get bigger.
Okay, once again, thank you, Egidijus. I'm very happy to have you here.
Thank you.